Let's listen to the State of New York Court of Appeals opinion on the property tax challenged by Tax Equity Now, NY, TENNY, Tax Equity Now. They're looking out for the big business and they're making believe they're supporting small business. So let's listen.
-1. State of New York Court of Appeals. Opinion. This opinion is uncorrected and subject to revision before publication in the New York reports. No. 1. Tax Equity Now NY LLC, Appellant, versus City of New York et al., Respondents, State of New York et al., Respondents. Richard P. Bress, for Appellant. Eden C. Burkett, for Respondent City of New York et al. Mark S. Grube, for Respondent State of New York et al. Citizens Budget Commission, Latino Justice PRLDEF, National Association for the Advancement of Colored People New York State Conference, Amici Curiae. Rivera, J. Plaintiff Tax Equity Now NY, LLC challenges New York City's property tax system, alleging that the system imposes substantially unequal tax bills on similarly valued properties that bear little relationship to the property's fair market value. According to the complaint,
that is actually true. There seems it has to do with when the property came on the tax roll. If it came on in 1890 or if it came on yesterday onto the tax roll, there's a big giant difference. It's similar to gangs or fraternities, or I guess fraternities that haze the new people. Right? That's exactly true, that what they said similarly valued property bear little relationship to the property's fair market value. So substantially unequal tax bills, that's for sure, on similarly valued property. Similarly valued property. That's exactly true.
According to the complaint, the result is staggering inequities in a regressive tax system that hurts those who can least afford to pay heavy taxes. The complaint further alleges that multi-million-dollar properties are taxed at similar or lower rates than less valuable. -2. Number 1 properties, and that real property in majority people of color districts are overassessed and subjected to higher taxes compared to properties in majority white districts. TENNY seeks declaratory and injunctive relief against city and state defendants for alleged constitutional and statutory violations caused by the city's tax scheme. Despite the comprehensive, detailed allegations and legal precedent supporting the causes of action, the appellate division dismissed the complaint in its entirety at the pleading stage for failure to state any claim. That was error. A pleading need only.
There you go. So we have to disagree with that statement that it is discriminatory. The law has no discrimination in it. It's simply where the property is and what its value was in 1980 or 81 when they started this whole game. And it is not the case that it's just minority. Every single case is a special case, right? So you can look at two houses right next to each other. If they did some renovation or something like that, that taxed very differently than the building right next to it. If it's a co-op or condo, they're taxed much higher thanks to the law, the way the law is written. It has nothing to do with race. It has to do with when it came on the tax roll and its class. So that is not a race issue. Now, or minority or whatever issue. Now they show that the complaint was dismissed and that was an error. That was error, is exactly what the opinion says in the pleading stage. I think that if it depends on minority versus not minority, majority. Because look at North Brooklyn. North Brooklyn includes things like Bed-Stuy, and it is going to be hurt by, in fact, most of North Brooklyn will be hurt by this change because their property values have gone up. Now, if you talk about Staten Island and the Bronx and parts of Queens, then yes, their property tax will go down because their market values haven't gone through the roof like North Brooklyn, right? And Park Slope. So it again, it has nothing to do with minority versus majority or whatever. It has to do with the market values. And I'm going to stop here because I recommend everyone read this whole thing. And in the end, the Court of Appeals said that parts of it are right, parts of it are wrong, but there was an error in dismissing the entire thing at the pleading stage. Thank you. Peace out.